We have with us today Christian Zeller from Manning, Gordon and Zeller. He is a managing partner there. He limits his practice to immigration and nationality law. Mr. Zeller offers expert representation in areas of immigration solutions for businesses, I-9 worksite compliance, which is a lot of what we'll be talking about today, all business visa categories, consular processing, appeals, and immigration-related federal court litigation. Mr. Zeller is individually AV rated by Martindale-Hubbell, the highest rating an attorney can attain in the areas of legal liability and ethical standards. Mr. Zeller is board certified by the Florida Bar in U.S. Immigration and Nationality Law, and he is admitted as a solicitor in England and Wales. Mr. Zeller serves as an honorary consul to the Republic of Austria, and Mr. Zeller has authored numerous articles on immigration and nationality law topics. He is a frequent speaker at bar associations, universities, and private sector interest groups, of which we are one. We're very interested in immigration, and we're very interested in good faith I-9 compliance. So welcome, Mr. Zeller. Thank you for being here.
My pleasure.
Yeah. So I'm going to start with some housekeeping. Just for everyone's information, everyone is being muted just for background noise and other things. So please use the chat box to ask any questions. The questions will be directed to at the end of the webinar. The presentation is being recorded, and we'll get it out to you within about 48 hours because we're going to cut back and edit some of it. The slide deck will be available at the same time. We'll probably have it all on one of our web pages at the New Mexico Restaurant Association. And if you don't see my screen right now, or if you don't, well, you can't hear me if you can't hear me. But if you don't see my screen, click on shared content. That might help you. The other thing I want to mention is that we've been having some problems with Comcast cable, and it's been going out. If the webinar ends abruptly, just know that it's probably our cable. We probably shouldn't try to all get back together again because we've got probably over 30 people on the webinar right now. But in that case, Mr. Zeller and I will get together. We will record the webinar and send it out to everybody if that's agreeable to everyone. Apologies, but Comcast is they're blaming the weather, which is perfect. Anyway, please welcome Mr. Zeller. Thank you so much for being here, and let's go ahead and get started on the content.
Thank you, Carol, and thank you for this kind introduction, and welcome to all participants. And with that, let's dive right into I-9s, and let's start out by way of history. Some of us remember the amnesty that has been granted during the Reagan administration in 1986. And by way of history, what that did, it granted benefits to approximately 3 million illegal immigrants or undocumented workers in the United States. They all got employment authorization, and subsequently they all got green cards, and a lot of them are citizens today. And that was part of that law. And the other side of that law was there had to be new enforcement in order to better control the border. And that was really a failure, because that was really the time when that law was implemented. That was the birth time of the I-9 eligibility, work eligibility verification compliance, but it was never enforced. And that was all in 1986. So basically what you had is 3 million people got their benefits, but the enforcement which was promised never took place. That was in essence the law that has been enacted under IRCA, which is the Immigration Reform and Control Act. And pardon the loyally abbreviations in there, 43, 44, and 45. Those are our previous presidents and our current president. And the abbreviations for OR and EE. OR is an employer, and then EE is an employee. So just again, by way of history, under President George W. Bush, there was increased I-9 enforcement, and it was very, very public. Some of you may remember the raids on the meatpacking plants in Iowa and in the Midwest. But what the Bush administration did at the time, they really went after the employers and not the employees, and they were very, very public about it. Then under President Obama, everything happened behind the scenes. And what Mr. Obama did, he actually increased I-9 enforcement over the Bush administration, but he did all behind the scenes, and they, again, went after the employers and not the employees. And if we fast forward today, our 45th president, Mr. Trump, is very, very public about immigration enforcement. I think you all hear it on the news on a daily basis, and he goes after employers and employees in the I-9 enforcement context. That means if there is a raid or if there is an I-9 audit in a business, not only is it the employer who is subject to civil or possibly criminal prosecution, but also the employees who might be there illegally may be subject to removal from the United States. And there's a certain trend that we are currently seeing in immigration enforcement. And what I'm showing you here, those are just a few. All you need to do is go online and Google worksite enforcement news, and you'd be surprised what is coming up. But the first two, I want you to note those. Worksite enforcement is already double. That was in January of this year. ICE is increasing I-9 enforcement this summer. Well, that is right now. ICE pledges a 400% increase in I-9 enforcement. I would suggest to you that anything that increases by 400%, that's a lot. All of you heard about how ICE targeted 7-Elevens nationwide. I think that was just a few months ago. And our own firm experienced an increase in I-9 audits. We have done I-9 audits for our corporate clients for many, many years. And we have never had any I-9 audits in New Mexico. And we have maintained our New Mexico Albuquerque office since, I think, 2006. And we've never had any enforcement at all until this year. We had several of our clients had visits from ICE, and they are now being audited. So just a word to the wise, even in New Mexico, we are seeing this trend. I want to share an interesting fact with you. And that fact, the 76%, that comes from ICE itself. 76% of I-9 forms have at least one finable error on that. Think about that for a moment. If you were to ship me or fax me a dozen of your I-9s, I'm likely to find mistakes on 8 of them. Can you imagine the fines you might be paying on that? That's very, very, very high. So if there's so many I-9s wrong, we really got to consider, what is the cost of that? What could be the potential business interruption on that? What are the fines on that? And is that still within the realm of a civil fine, or are we looking here at criminal prosecution? So with that, I think we ought to talk about what is good faith compliance within the I-9 context. And here's a list, and then we'll go through all of that. Well, first, of course, it's common sense. You got to start out with a meticulous I-9 maintenance. I-9 maintenance is something that is, you can't shove it aside. You're taking care of your payroll. You're taking care of all your other things administratively. You got to pay credence to the I-9 household as well. Of course, you can't discriminate when filling out I-9s, meaning you got to do it for everyone and not just for the ones you think you ought to do it. You have to have ongoing staff training. Things change in all of our businesses. HR managers leave, HR specialists leave, or whoever you put in charge of your I-9 household may leave, so there's ongoing training. And then you always ought to prepare for an ICE audit. Think about that for a moment. Would you ever consider not filing an IRS federal tax return? Would you ever consider, taking that lightly? Would you ever consider messing with the IRS? Those of us who have ever been audited by the IRS, you can't ever shake them again. Well, ICE is the same thing. I'd rather be audited by the IRS, by the way, than I'd be audited by ICE. And then, of course, you want to do an internal audit, because there's nothing better than prevention. Why wait? Why be complacent? And why wait until ICE actually shows up at your door? So who really enforces those immigration laws? Some of us remember that in the past, we had the INS, the Immigration and Naturalization Service, and they did everything. They let people in the country, they threw people out of the country, they got you your green cards, they did everything. And then after 9/11, the Bush administration changed that and divided this agency into 3 sub-agencies. One of them is the USCIS, which is U.S. Citizenship and Immigration Services. And that's the service agency. That's where we get our benefits. That's where we get employment authorizations. That's where we get green cards. That's where we get citizenship. Any immigration benefit is issued by the USCIS. And then we have CBP, which is Customs and Border Protection. And I know all of our friends in New Mexico are very, very familiar with those Ford Broncos, white Ford Broncos with the green stripes on them. That's Customs and Border Patrol. And those are the folks who patrol our border, so they are responsible who comes into the country. And finally, then we have ICE, and that's really the agency we are talking about today. And ICE is Immigration and Customs Enforcement, and that's the agency which enforces the immigration laws within the United States. But I will suggest to you, who's really enforcing the immigration laws? It is you. It's not really ICE. I mean, imagine that. You are actually charged with enforcing the immigration laws of the United States if you are an employer. Because ICE doesn't send you employees, do they? No, an employee, a potential employee shows up at your door and it becomes your responsibility to determine whether that applicant is authorized to work in the United States. And that's, of course, where I-9 compliance comes in, where you have to deal with I-9 workforce enforcement, whether you want to or not. It's statutory, it's regulatory, you can't do it. So you got to deal with that I-9. Look, I know I have, and I know you probably have, bought something in a store that it said on the box, some assembly required. And then you bring it home and you take it apart and there's a 2 or 3 page manual and you put that thing together. If it's made in China, maybe I could screw it too, I'm missing. But you can put that thing together and you have a piece of furniture. The I-9 is quite different. It's a 2-page form that comes with a 65-page government instruction manual. Think about that for a moment. A 2-page form requires 65 pages to explain to you on what to do with it. But that's not all of it. When you print out an I-9 form, and by the way, you'll find it at uscis.gov. Just go to the forms and look at the I-9. The I-9 itself has an additional 15 pages of instructions. So we know that that is serious. Let's go through some of those basics. We know the form is fraught with pitfalls because if I need a 65-page manual to get it done, something's got to be wrong with it. So who fills out that form, really? Do you know? When do you fill it out? And do you really need an I-9 for everybody? So here are some of the basics. Most important thing, always use the latest Form I-9. If you don't just print out 100 I-9s and then keep on using it and give it to your HR person that they fill it out, no. Print each form fresh from the USCIS webpage and you'll be sure that you will have the latest form. And that form, what it does really 2 things. It verifies identity of who is applying for that job, and it verifies the work eligibility of the person who's applying for the job. And we'll talk about that in more detail on how you do it. And again, you gotta treat everyone the same. There can't be any discrimination within the employment context when it comes to filling out I-9s. So here's what you have in the form. It's a 3-section form that has a list of acceptable documents, 15 pages of instructions. And what you really should do is you should use the Handbook for Employers. And if you don't have the Handbook for Employers, just Google M like Mary 274 Handbook for Employers. It'll pop right up. It's an excellent document. It's the 65-page instruction manual we've just made fun of, but it is really a very, very good tool, and it answers a lot of your questions. So let's dive into the basics here. When do you really fill out the I-9? Well, the employee who is applying for the job must fill out Section 1 of the I-9 on the first day of employment. And the first day of employment is the day you're starting to pay that employee. And then there's another section that all of you know that needs to be filled out on the I-9, and that is Section 2. And the Section 2 is reserved for the employer. And that goes by what the government refers to as the Thursday rule. That means that you have to fill out the I-9 within 3 days of the person beginning employment with your firm, with your company. And it's called the Thursday rule because the first day of employment doesn't count. So if that person starts working on Monday, then you go Tuesday, Wednesday, Thursday, there you are. Thursday is your third day. So that's why the government calls that the Thursday rule, but that is your last chance to fill out that I-9. So what happens when you fill out that I-9, in Section 2, the employer has to do several things. You have to actually look at the document that you're putting onto that form. You can't just look at a copy. The employee can't just tell you about the document. They can't show it to you on their phone. No, you got to see the actual original document. And what you need is either a List A document or one List B document and a List C document. And here's why. A List A document establishes both identity and work eligibility. And if you look on page 3 of any I-9, that's where the list of acceptable documents is listed. And what you should do, you should give that list to the employee, and he or she can select whatever he or she wants to show you off of that list. Don't just tell them, give me your driver's license and a social security card. They have a choice on what to show you. So for example, a US passport is a List A document because a US passport shows identity because it has a photo on it, an expiration date, and it also demonstrates work eligibility. Now, if someone doesn't have a List A document, they can give you a List B and a List C document. For example, that could be a driver license and a social security card. And as you know, a driver license obviously establishes identity, and the social security card establishes work eligibility. But you need the combination of both because one document by itself does not establish both eligibility and identity. And that's something new. A document can no longer be expired when it's been shown to you. Only in the renewal context, let's say someone has a green card or a work authorization from the USCIS and they now get a new one. If they can show you that they have applied for the renewal, then you can still look at an expired document. But when someone starts out working for you, you have to see an unexpired document. There's a ton of acceptable documents. And if you look on the second row to the left, I mean, that's a green card. They are now actually green again. If you look to the right in the second row, those documents, those are the original green cards. That's why they are called green cards. That's a real green card. Many of us won't see those anymore, but some of them are still out there. So green cards come all shapes and colors and forms and what have you. So take a look at the M274. They have quite a variety of eligible documents, pictures of eligible documents in there. And that has always been a big help also in our office and a big help to many of our clients. Now, you may ask yourself, are these documents real? I mean, someone shows you, an identity document from a foreign country, it's a passport or something, or someone shows you a green card. Do you know that the green card is real? I don't know. I mean, if I would have seen a green card 25 years ago, I could tell you whether that green card was real or not without a doubt. But today, with the technology we have today, I can't tell you anymore in many, many cases whether that green card or that employment authorization is really a real document. But rest assured, ICE is keenly aware of that, and you are not charged with being a document expert. The document has to look real to you. If a person is in their photograph on a driver's license or a passport with their dog, it's probably a good indicator that it's not a real document. But if the document looks real to you, then it is a real document. So now that we looked at the documents, there's this big question, and you will read this in the M274, the government gives you a choice on whether to copy the supporting documentation or not to copy the supporting documentation. So if you look at the Social Security card and a driver's license, are you gonna make copies of that or not? I used to be of the opinion, don't copy it because you're just creating a liability by having this around. But I have since changed my mind several years ago, and I'm now of the opinion it is better to copy the documents. And because if you copy the documents, you can demonstrate by in an ICE audit that you have made a good faith effort to actually look at real documents because you now have copies that you can show what you actually looked at. Beware though, you have to be uniform about that. You either copy all documents of every applicant who shows up, or you copy no document of all applicants that show up. So you can't just be selective about that. That would fall within the purview of discrimination again. And another thing that's really important, with your document storage, don't keep your I-9s together with your payroll records. Most places I go to, that's exactly where I find them. It's an absolute no-no. The I-9s have nothing to do with your payroll. They have nothing to do with your other HR or business documents. Keep them separate. Well, how long do we have to keep this nonsense around? Well, here's what the M274 says. The M274 says you got to keep the documents into copies either 3 years after the date of hire or 1 year after the date of employment is terminated, whichever is later. I mean, that sounds like a math a question to me, and I became a lawyer not to do math. But here it goes. So if you have a John starting to work for you last year, and he's just worked for you exactly for 1 year, and then John quits, how much longer are you going to keep that I-9? Well, you're going to have to keep it for another 2 years. Well, and if John has worked for you for, let's say, 5 years, and he quits today, how long do you keep that I-9? Well, you're going to have to keep it for another year. But here's the good news. Go to page 31 of the M274. And on page 31, the M274 has a formula that is absolutely foolproof on how to monitor that. And it tells you just plug in the numbers and you'll be on the safe side. Now, while we're talking about compliance, I want you to get 4 folders. If you have not done so already, here's folder 1. In folder 1, we're going to put all of our current Forms I-9. Those are the employees that are currently working for us. And I'm keenly aware, that in your industry, in the restaurant industry, in the hospitality industry, the turnover can be tremendous. So this could be some real headache, but we're going to have to get through that. So what you do in that first folder, you keep the I-9s of the current employees, you keep it in alphabetical order. And then just attach the supporting documents of which you have made copies of to those Forms I-9 and any E-Verify receipts. And by the way, we're not talking about E-Verify today. If anyone is interested in E-Verify, then pose a question to Carol and we'll be happy to answer that. But it's too big a subject matter to within the framework of this webinar today. And then keep a list of all current employees in that folder. And of course, your payroll list, the current payroll list, of course, is the best tool to show which employees are current. So that's your first folder. Then in folder number 2, that's all the terminated employees. And remember, we have this retention requirement with the I-9, so that could be a big folder. So file by month and year when they were terminated based on the date they were retained. And that's where the formula on page 31 of your M274 will come in very, very handy. And then remember that retention requirement. You know, you can't get around that. And then please destroy everything that you don't have to keep anymore. In other words, once you have satisfied the 3 or 1 year after termination retention requirement, throw out that stuff, throw out that I-9, and throw out the copies of the documents you made. There is absolutely no reason for you to keep past liability sitting in your office for an ICE officer to see when he or she wants to audit your documents. So you're absolutely allowed to destroy those. As a matter of fact, I'm advising you to destroy them once you're done with them. Now here's folder 3. And in folder 3, you put in the I-9s that require some kind of monitoring. Many of us hire foreign national employees who have a work authorization. That work authorization is never permanent, it expires. You know, you need a tickler system to figure that out, you know, when you need to re-verify. Some of our workers, you know, come here with visas, H-1B visas, H-2 visas, F-1s, J-1s, whatever the case may be, but those visas expire. You need to make note as to when you have to re-verify the employment eligibility of temporary workers. And then in folder 4, you know, I'm reaching very far here. If you don't have that, then it'll be a good idea to get that. You want a written company policy on how you maintain your I-9 household. You also want, you know, any corrections that you ever made on I-9s, you want those noted separately. You want those noted separately. And we would want to know whether you have any training materials. If you don't, then it'll be a good idea to develop those. And then you want subcontractor agreements if you have any. And we'll talk about subcontractors a little more later, but it is very important that you know, if you do have subcontractors, whether their workforce is legal. And if you have any agreements with subcontractors, you know, that is something that could be in that agreement where you can require your subcontractors that they make sure that their workforce is legally authorized to work. So do we really need an I-9 for everybody? At some point in time, I said, yes, we do. We got an I-9 everybody, but do we really? No, you know, that really depends on who is everybody. Everybody is really someone who is an employee. And keep in mind, you know, that if you call someone an independent contractor, that does not necessarily make them an independent contractor. In other words, if you control the means and manner on how that person performs their work, then they are an employee for I-9 purposes and probably for labor law purposes. And it doesn't matter whether you W-2 them or whether you 1099 them. They are employees. In other words, if you tell someone to show up at 8 a.m. and they have a lunch break at noon, and then you tell them to go home at 9 and you provide a uniform for them, they are not an independent contractor. They are an employee because you provide the means and manner on how they perform their job. What about the friendly crew that comes to mow your lawn? Are they your employees? No, they are not. They are true independent contractors. How about the IT guy, you know, that fixes your web page and, you know, and you call him or her once a month, you know, to figure out what's wrong with the computers? Are they employees? No, I don't think so. They are true independent contractors because they just invoice you, and when you call them, they're typically not available. So you do not control the means and manner on how they perform their work. You see the term Walmart on there, and it's on there for a reason. Some of you may remember that Walmart settled a case in 2005 with ICE for $11 million. And at that time, Walmart had cleaning crews who were independent contractors working in Walmart stores after hours. They were not Walmart employees, but Walmart management had constructive knowledge that many of those workers may be undocumented. And I started digging and digging until Walmart decided that's bad publicity. We're better off just writing a check. $11 million is a lot of money. So we'll talk about subcontractors and how much we want their workforce to be legal. Look at the facts and not the faces. And I know Carol said she's going to send out the PowerPoint to you. So this is a slide I want you to go to because it's very, very important. The Immigrant and Employee Rights section of the Department of Labor, the Department of Justice, has actually an 800 number for employers. So if you are unsure about anything with respect to discrimination, you can call. You don't have to give your name or anything. And you can actually speak to an expert there, and they will tell you what to do so you can conduct yourself on the right side of the fence. And in addition to that, I put a web page on there, and take a look at that. You should really have that. You should print that out. It's only a one-page document. It shows 10 steps on how to avoid discrimination. It has questions on that you are allowed to ask. This is a document that should go into your compliance program. It should be in your I-9 folders. Whoever deals with I-9s should have access to that. A very, very important thing to have. So now let's go to why we are really here today, and that is ICE is coming to visit us. Now, what would you prefer, a raid or an audit? Well, I think I would prefer an audit, because if you have an ICE raid, you and your business are not having a good day, because then the guys in the picture on your left side, that's what they will look like. This is how they will show up, and more than the 3 you see here. There'll be a whole bus of them. But an audit does not have to be a bad experience if you are prepared properly. So what do you do when ICE knocks on the door? The most important thing, your host or hostess must be trained. Your host or hostess is trained well to receive guests in your establishment. That's what they know how to do. But they don't know how to deal with a federal agent busting in the door. So training is the only way, to give them a level of confidence that your staff actually knows how to conduct themselves when ICE shows up. The most important thing, if they don't have a warrant, I would never let them pass the front door, because that makes no sense. The first thing you ought to tell them, thank them for coming, and then let them know that you have legal representation, because you are entitled to legal representation in an ICE audit or in an ICE inquiry. And when I say entitled to legal representation, that means at your own cost. In other words, the government is not going to give you a lawyer and pay for it, but you are entitled to be represented. So here's the difference. And we're not talking about a raid now. We're talking about the difference between Elliot Ness coming in with a warrant or a federal agent coming in with a notice of inspection. Now, if an ICE agent or more show up at your place of employment with a warrant, then your host is not going to have a choice. The host is going to have to take the warrant, get a supervisor, have the supervisor look at that warrant, and you're going to have to let those agents in, and they can conduct themselves at will on your business premise within the framework of what that warrant says. And this is likely, okay, we're taking all the computers, we're taking all your paperwork. Versus a notice of inspection. And that's, of course, a very, very big difference. And I will tell you that in 99% of the cases, we're dealing with a notice of inspection and not with a warrant. And let me also say, that a notice of inspection has to be signed when the officers come in. Don't refuse that. In the law, we have something that is called service of process, meaning, if ICE wants to serve you with a notice of inspection, it's going to happen, whether you like it or not. So there is no ifs or buts about that. There's no two ways about that. But there's a good way for you to handle it, and that is, to train your host or hostess. And you can accept that notice of inspection. Once you get that notice of inspection will instruct you to do something. And what it does, it will tell you to produce your I-9 records within 3 business days. And the I-9 records that ICE typically asks about, and I have done many of those audits, and it's always the same thing. They will ask for your payroll records for a number of years. They will ask for your IRS forms 940 and 941s, because as you know, those are your employment taxes. They will ask for likely your W-2s, not always, and of course for all of your I-9s. And you have 3 days to produce those documents. I am, of course, biased, and I freely admit it. I can tell you that whenever I have been involved in an ICE audit with ICE from day one, I have always, without exception, gotten an extension on the 3 days. ICE has always allowed us, if we communicate it properly, if we give them a good reason that we need more time to produce those records, I have always gotten it, but it's got to be a reasonable period of time. But I've always gotten a week to 10 days. And that's, of course, a whole lot better than 3 days. If your business only has 25 employees, well, then, of course, the 3 days is going to be fine. But if you have hundreds of employees, or if you have multiple locations maybe, and your I-9s are kept in multiple locations, or if your accounting is done on a separate location and your payroll records are not on premise, sometimes more time is very, very much appreciated. Yep, they do. ICE wants your originals. So you can't just give them copies of your I-9s. You're gonna have to turn over those originals. I have worked with ICE agents in several cities, and some actually make the copies, some don't. I suggest that you make your own copies, absolutely, and when you turn over your originals, get a receipt from ICE. This will not be a receipt on a napkin, I assure you. ICE has its own receipts, especially produced and printed by the Office of Management and Budget, for I-9 receipts. So they have that, but you gotta insist on that you turned in 95 I-9s and so many, payroll records and what have you, because those are records that are yours. You need them, so please do not hesitate to ask that receipt. That's just in the course of business. So now we've turned over our documents to ICE, and now of course it's all going to get fun, and here are the different possibilities. You could be in compliance and get a compliance letter. Well, don't just jump up and down. I've been doing this for many years. I've never seen one of those. That someone is just in compliance up front. I mean, that, maybe if you have 3 employees and you're really taking care of that, and you're doing an in-house audit now, remember the 76% finable errors on the I-9s? Well, if 76% of are wrong, it may be kind of hard to just get a compliance letter up front. But it is possible, of course. Then there is a notice of discrepancy, notice of suspect document, notice of technical or procedural failures, and a notice of intent to fine. And those we need to go through, because those you need to understand. Now here you have the notice of discrepancies, which is kind of weird, because it's telling you, something's wrong, but maybe it isn't, or maybe it is. So ICE, when they get your I-9s and your documents, they have access to databases that you and I do not have access to. So they find out that Jose's green card is really John Hancock's, and they find out that the employment authorization from Pedro Rodriguez is really Paul or somebody else, but they are not sure about it, so they have to do research on it. But they will let us know ahead of time, something isn't really right here, we're gonna need more time, but this is what we have seen so far. And on this notice of discrepancies, they will tell us what they think might come down the pike. At this point, you as the employer, there is nothing you need to do yet. The next thing is, you're going to get a notice of suspect documents. And a notice of suspect documents, now we know that something is wrong. And remember, you are not a document expert. When you looked at those documents originally, they looked real to you, and if they look real, then they are real. So So who's really at fault here, the employer or the employee? Well, in this case, now it's the employee. If you looked at those documents in good faith and they looked real and they, you know, of course, you know, if you have 25 employees and all of their green cards come from the same manufacturer and that manufacturer is not the USCIS, you know, then you may have something to do with it. But if one or the other document is wrong and it looks good to you, then you are fine. So this is when we find out whether something is wrong or not and whether we have to terminate someone. If ICE tells us, well, this person is here illegally, well, now it's time to have a come to Jesus with that person. I will tell you, once your employees find out that there's an ICE audit ongoing, I have found that employees who are unauthorized, they tend to hand in their notice fairly quickly. They know that they're here unauthorized. But here's the thing that you will deal with most. In the notice of suspect documents, there will also be a notice of technical and procedural verification failures. And there are really two different ones. On one hand, we have substantive verification failures, and on the other hand, we have technical verification failures. And that is something that you're going to have to remember what it is. A substantive verification failure cannot be fixed, but yet we have to fix it. What does that mean? If I do something so wrong that I can't fix it, and I will tell you what those are, then I can fix it today, but there's a 5-year statute of limitations. Meaning, if I fix that substantive verification failure today, after 5 years, ICE can no longer find me on that. So you can now see the importance of an internal audit, because if I can find a substantive verification failure and I can fix it today and I don't get audited until 5 years from now, you know, I'm not gonna harm my business because of that. And then there are technical verification failures, and technical verification failures, they can actually be fixed within a 10-day time frame. So here you have some examples of substantive verification failures. A person starts to work on Monday and you are not filling out the I-9 until 3 weeks later. You can't fix that. It's a substantive verification failure. The employee fails to sign, or you fail to sign the I-9. If the person has a green card and you're not putting on the alien number. You're not recertifying stolen documents. You're not reviewing documents. Well, the best way to review documents is, of course, to put them with the I-9s. And by the way, you know, when you review, and what that means, if you make copies of those documents, let's say a social security card and a driver's license, don't just attach them and think because the documents are attached now you don't have to fill out section 2 anymore with that driver's license information and the information about the social security card. You still got to put that on. Here are some technical verification failures. Failure to use a current form. Failure to use the English version of the form. I know there's a Spanish version of the form. I don't even know why we have it, because the only persons who are allowed to fill that out is if your employee comes from Puerto Rico. And I know in New Mexico you have many, or most of your employees probably in the hospitality industry are Spanish speakers, but you're not allowed to use the Spanish version of the I-9. You have to use the English version of the I-9. If your employee does not speak the language, you have to get an interpreter, and then of course fill out the interpreter section of I-9. Failure to provide a date of birth or maiden name. Failure to provide the translator information. And keep in mind, those are now things we can fix within 10 days. That means, you know, if we go back to the 76% of finable errors, let's say they are not substantive verification failures, but they are technical verification failures. If we can fix them all, we won't be fined. And we have 10 days to fix them. So here are just some of the examples as to what are technical verification failures. So what happens after ICE, after we do all of that? Well, ICE is going to figure out on how much that is going to cost. So if we have substantive verification failures, this is the latest. By this slide, you got to get nauseous. Seriously. Or if you don't correct the technical verification failure, then it becomes a substantive verification failure. And if you look at the percentages on the left-hand side, that is the percentages of your I-9 failures. So if 76% of them are already wrong, well, it'll be a good idea for us to fix them, right? Because if 50% or more of them are still wrong, then I'm on a first offense, I'm looking at $1,862, and that is per violation. So if you have 36 violations on that, I'll let you do the math, what that means. So you can see the value of an in-house internal audit to get our I-9 household in order. If you knowingly hire unauthorized workers, they really don't like that. If I says you knew about that, you had actual knowledge that they're illegal, or you brought them across the border, or you should have known because their green card looked so fake, you should have known, and you still hired them. Those fines, as you can see, they really escalate. And that again is per violation. That's not per business, that or per audit, that is per violation. I can just give you some examples from our own firm. I have just done an I-9 audit, and I cannot disclose everything, of course, for attorney-client privilege reasons, but what I can say is that it is a landscaping architect firm, a very, very successful, and they did not know that there were a number of unauthorized workers in their business, but there were still several dozen of them. The proposed fine by ICE was $225,000. When you get a letter like that, you're gonna sit down, and that's not that big a business. I had a business that sold fishing equipment. They had, I believe, 12 employees, none of whom, and I repeat, none of whom was unauthorized. They were all legal. They were all United States citizens. However, the employer never heard about an I-9. He did not know that they existed. Proposed fine, $36,000. There was no violation. The only violation was he didn't have any I-9s, but no illegal workers. So this is not something to to make fun of. ICE agents, have some sort of a discretion, and when they look at I-9s, they can see trends. That's all they do all day long. These I-9 auditors, they look at I-9s all day. You can't explain things to them. It's like explaining to a traffic judge, I did not see the red light, or it didn't look like a yield sign. You can't explain that to an ICE agent because they've seen it all. And depending on the totality of the circumstances, they can aggravate the fine by up to 25%. But they can also mitigate the fine by minus 25%. So if I go back to the person, who had no I-9s because everybody was a United States citizen at the $36,000 rate, that was already mitigated by 25%. So still, if there's a mitigation of the fine, you're still going to pay a lot. However, the ICE agents are not the people to negotiate the fine with. As lawyers, we actually negotiate those fines, and we negotiate those fines all the time. And in your case, in New Mexico, we have to go to El Paso. That's where the Office of Chief Counsel is on Hawkins, where we also have an office. And that's where Chief Counsel's office is, who actually assesses those fines by the recommendations of the ICE agents. And we have been successful in negotiating fines, down to lower levels. And sometimes, the Office of Chief Counsel is not willing to negotiate a fine, depending on the circumstances. And then, of course, you have the ability to go to court, and that's OCAHO, that's the Office of the Chief Administrative Hearing Officer. Let our government come up with a term like that. But you can certainly bring this to court and then litigate that fine in court. And we all know, as business owners, the first loss we take is the smallest one. So sometimes, it may not make sense to litigate that. And when Carol sends out this PowerPoint to you, this is a good flow chart for you to go back to actually see, how the ICE I-9 audit process works. But more importantly, what I want you to do is you gotta think about doing an internal audit. After you've just heard about all the bad stuff that can happen with ICE raiding your business or ICE, serving you with a notice of inspection, why not insulate yourself in your business from this ongoing liability, and do an in-house audit. Be proactive. And we recommend to all of our businesses to audit at least once a year. If you don't know how to do it, if you do not want to reach out to our firm, reach out to your immigration counsel, but reach out to a competent professional who knows how to guide you through an in-house audit. Once you've done it once, you'll know how to do it yourself the next time around. It's well worth the investment. And that I-9 audit really ought to consist of 4 different aspects, and that's the I-9 audit in and of itself. There's got to be a compliance program audit. So are we really in compliance, and how do we do that? Are we training our staff correctly? There has to be an anti-discrimination audit, which can be done very, very quickly. And then, of course, there's got to be a liability audit. What's that going to cost us at the current state of affairs? Do we have substantive verification failures? It's going to be 5 years until they go away. What if? I think that is obviously something, as a business owner, I would want to know that. So the simplest way to do it is, cross-check all of your I-9s of the current employees against the payroll records and make an assessment of the missing or the questionable I-9s, and remember the 4 folders, that we talked about earlier, and Carol is going to send you those anyway, so you have a complete guide on how to set that up for your business. And the next thing you want to do is, check for any remediate, substantive, technical, or procedural errors. And again, the substantive and the technical verification errors, now's the time to fix them. Just a word to the wise on cross-out versus whiteout. There is no whiteout in the I-9 context. Do never, ever white anything out on an I-9. It'll turn into a substantive verification failure. What you do is you cross it out. And by crossing out, I don't mean painting over it or crossing it out with 18 lines. 1 line crossing out is sufficient. Then make the correction next to the cross out, initial it, and date it. That is really all which you must do, and don't do any more. Is there any evidence of knowingly hired or knowingly continuing to employ undocumented workers? You definitely want to know that, okay? Let me tell you how you have constructive knowledge. If there's gossip in your business that someone is unauthorized, you have constructive knowledge. It's that simple. If you know that someone is illegal, you have actual knowledge. So here you have the difference. Actual knowledge is, if you have knowledge, you know it, and you will be held responsible by ICE if they do an audit. Again, on constructive knowledge, I always say it's the in-house gossip that will lead you to constructive knowledge. So you don't want to hang out at the water cooler if you don't want to know. And there you have it. At the end of the day, it boils down to, the business judgment rule, in your business versus bad faith. And you all know the business judgment rule is there, where you as the director or the owner of a business make a decision that is well informed and in good faith, and it's in the best interest of the business, versus bad faith. So you have to draw that line, where that is. And with that, Carol, we are ready for questions for the few minutes that we have left, if there are any questions.
Well, wonderful. And I'll tell you just briefly, we do have a few questions. I'll tell you briefly, I had an I-9 audit back when I was in the restaurant business, and this was soon after all of that went into play. I had not filled in the address of my restaurant at the very bottom, and I don't know if that's still a requirement, but I hadn't filled it in because I was keeping those in my files at work. There was no question where they were, where I was. I put in the name, etc. And when I had the I-9 audit, of course, they were being a little bit more lenient back then, but I got to fill those out, but I had to fill every single one out with all of the information. So every single bit of information has to be on there.
Like it was then, it is now, Carol. That was a technical verification failure. You had 10 days to correct that circumstance, and that is why where the leniency came from.
Well, exactly. Thank God. So let me get to some of the questions. The first question is, can you fill out a new I-9 on current employees?
If you have already filled out an I-9 for that employee, no, you cannot. Unless you are re-verifying employment, you can either use Section 3, the re-verification section, or you can attach a new I-9 to the old I-9. If you fill out a new I-9, then attach it to the old I-9. But there is no reason, unless it's re-verification or a rehire, there's no reason to fill out a new I-9. If you do not have an I-9, if that is the question, for that employee at all, then yes, now is the time to fill it out. It's a substantive verification failure. That failure will go away within 5 years, but now's the time to fill it out. But please do not backdate anything, ever, on the I-9. Fill in the true information.
Good. And then you said, and I didn't hear this, but that we have to have a maiden name, but this person didn't see that on the I-9 form. Is that, can you explain that?
No, I can't. I'd have to look at the I-9. I'm doing that right now.
And I don't remember you saying that, but
yes, other last names used, if any. It's on
okay.
It's on the first line. It's on the first line of Section 1. What the employee fills out. And of course, if it were a female and she has changed her name, or if she has used a maiden name at one point in time, then that would fall into that section.
All right, brilliant. So in a multi-unit restaurant business, the new employees don't always come to the office to fill out paperwork, but show their original documents to a store manager. Are there any supplementary steps we should take to make sure the office gets the correct information?
That's an excellent question. That restaurant manager at that restaurant who looks at the documents is an agent of that corporation, and he or she should also complete the I-9. In other words, let the employee complete Section 1, then have that manager look at the documents that the employee brought to show identity and work eligibility, and then that manager would complete Section 2 and sign Section 2, keep a copy of the I-9 at that restaurant, and ship the original with the copies of the documents to your corporate office.
All right. Can I keep the employee documents in the employee file and separate from the I-9?
No. The I-9 documents should be kept separate, and the documents you copy. And I'm speculating now how this question was asked. Many people, or the majority of the people, show a Social Security card for work eligibility. And HR always uses, of course, the Social Security information for payroll records and for so many other things. And that's how copies of Social Security cards often end up in the payroll section when they should be with the I-9. And if that is the case, then make another copy of that page, but you have to keep the I-9 documentation separate. And that means the I-9 form itself and the copies that she took of the documents that the employee showed you at the time of hire.
Okay. So next question, what about if they have a new ID card? Do we fill out the list info with the new ID information with a new form? And I think you already answered that. That's where you use Section 3. Is that correct?
Well, not always.
Okay.
If let's use two examples on that. If the person has a work authorization from USCIS, and that work authorization requires, and that caller who posed that question is asking, where to put that, then your answer is correct, Carol. Then that would go in Section 3 of the I-9, and that person, you re-verify the eligibility of or the veracity of that document in Section 3. If, however, a person starts work for you and they present a New Mexico driver license and a Social Security a card which has no annotations on it, in other words, it doesn't say only valid for work with DHS authorization or anything like that, and then the driver license expires. No, they need not ever bring anything else again. So if that identity document expires at some point in time, that is not for the employer to re-verify that.
All right. So next question is, can you take a temporary ID as the photo ID? Sometimes if someone lost their ID, MVD gives a temporary and the new one comes in the mail.
Absolutely. As long as the temporary ID establishes identity, and identity means the document is valid today, the document has a photograph on it with the likeness of the person showing it to you, and it is signed whatever it is. That could be from the DMV. That could be a student ID for all we know, to establish identity. I encourage the caller who asked that question also to print out and take a look at Form I-9 on page 3. There it shows the list of those acceptable documents. But absolutely a temporary, look, even a driver's license who's permanent is a temporary ID because it's only valid for a certain number of years.
All right, and then I'm going to use this as the last question. Are I-9s required to be housed in the store? And let's also talk about chain restaurants, which you talked about a bit before, and do Social Security cards have to be signed?
Well, Social Security card, if it is presented for work eligibility, yes, it has to be signed. Otherwise, we don't know, whether it belongs to that person. And where you house your I-9s is up to you. They have to be accessible, remember, within 3 days when ICE serves your notice of inspection. I always recommend central storage of the original I-9 so that you don't have all the I-9s. If you have a restaurant chain, that you have I-9s in all the various places, it can become very, very onerous to first, actually try to be in compliance, because you start losing control. And if ICE comes knocking, it may take you, quite some time, to garner all your documents.
Great. Thank you so much. I have one last question, and that is, this may put you on the spot a little bit, but I know that my members are also worried about, the I-9s is one piece of what we deal with, and documentation, but raids are also a fear, and getting to be more of a fear. Would you be willing to come back on and talk to us about raids, and what do we do when somebody shows up at our doorstep?
I'll be happy to.
Okay, that would be great. And I think people would be very interested in that. So thank you so very much. We very much appreciate everything.